All right. It appears to the court that a responsive answer to a question propounded would furnish a necessary link. Let me read it like I have some sense. Responsive answer to a question propounded would furnish a necessary link in the chain of evidence which might implicate or convict the witness. He may properly claim his constitutional privilege. Obviously, the privilege prevails where a question upon its face discloses that a responsive answer may incriminate him. But where the question upon its face is innocent, serious difficulty of adjudication may be encountered. Looking further into the general construction of the provisions of immunity, it is uniformly recognized that it is for the court and not the witness to say whether refusal to answer is justified. Should it appear to the court that in the setting in which the question was asked, there is reasonable possibility of exposure to prosecution or involvement in a crime by reason of a responsive answer, the claim of privilege must prevail. But the danger of self-incrimination to be apprehended, this is what we read before, must be real and substantial in the ordinary course of things. For the law does not permit a witness arbitrarily to hide behind an imaginary or unappreciable danger or risk. The particular question which a witness refuses to answer may not be considered in isolation. In adjudicating the right of immunity, the court must be able to discern from the character of the question and the other facts adduced in the case some tangible and substantial probability that the answer of the witness might help to convict him of a crime.
Your Honor, it's based on the question. It's not based on the answer. And that last part of that really drove it home. It's the question that's being asked. Is the question going to be asked? I mean, again, I think the innocent questions that were discussed in that section are what the government plans on asking. Those are going to be innocent questions. The ultimate issue is going to come down to the cross-examination or when Ms. Harmon is going to be recalled by the defense. That's the issue. And she can't just decide, I'm going to testify for the government and I'm going to invoke for the defense. That's been long established as not a possibility. So we're looking ahead at what the defense is going to do, and the defense is going to ask her and paint her as the alternative suspect. So the nature of the questioning, her line of questioning, is going to potentially expose her to the risk that she could provide evidence one way or the other. She could provide evidence against herself. That is the nature of the Fifth Amendment, is to avoid providing evidence against yourself. These are not going to be innocent questions that are asked. These are going to be point blank accusations that they want to, I mean, we all know Mr. Griffiths is going to be testifying that she is going to attempt to testify that she's the one that committed this crime with her son. So ultimately, those are not innocent questions. This case is dead on point that she is entitled to invoke. And that the court must look at the nature of, we have the nature of the questioning and then the nature of where it's being asked. She's going to be under oath asked these questions. There is no other place in which privilege should attach greater than in the courtroom where a person is under oath being asked questions that are accusatory, that are meant to create a Perry Mason-like moment in here. So, Judge, I don't see any other way around than for her to invoke and this court to find that she's entitled to invoke, and that it's unfortunate. It's going to factor into Mr. Martin's Sixth Amendment right, but that's not preventing him from testifying. He can elicit this information through his testimony.
And Your Honor, this is something that we touched upon previously, but McLemore actually says the opposite as well. We noted that whenever somebody pleads the Fifth, they can't be a piecemeal. They can't take the stand and testify about some things and not some things. But in Macklemore, citing the Combs Court, quote, simply by taking the stand, the witness would have to waive her Fifth Amendment Fifth Amendment privileges, and we can't piecemeal what she is going to waive and what she is not going to waive. The second the court says that she has to testify and somebody asks her, did you commit this crime? She cannot at that point say Fifth Amendment. The second she takes the stand, the Fifth Amendment is waived. So that's why it's the question that's important.
Well, I think Ms. Jones is right. Upon reading Young versus Knight a little more thoroughly, it says, much has been written on this subject. The U.S. Supreme Court seems to have covered the whole matter in Hoffman versus the United States, a 1950s era case, in saying that if a witness, upon interposing his claim of immunity, were required to prove the hazard in the sense in which a claim is usually required to be established in court, he would be compelled to surrender the very protection which the privilege is designed to guarantee. To sustain the privilege, it need only be evident from the implications of the question in the setting in which it is asked that, and here's the crux of it, that a responsive answer to the question or an explanation of why it cannot be answered might be dangerous because injurious disclosure could result. That extrapolation of this ruling changes my mind. I'm going to quash the subpoenas and allow the witnesses to invoke the Fifth Amendment.